Good morning in Mexico, good evening in China, and thank you for joining us for this webinar on the evaluation of the role of international and regional courts and tribunals in the face of interstate conflicts in the 21st century. My name is Mariana Salazar. I will be the moderator of this panel. In the name of the Mexican Council of Foreign Relations, COMEXI, it is an honor to be participating as a moderator in this event. I want to first of all thank you all for joining and thank our distinguished panelists for joining from different time zones throughout the world. So we will proceed as follows. We have 10-minute presentations by each of our panelists, and then I will open a session of questions and answers. You have the possibility to introduce your questions in the chat box of this Zoom meeting, so please feel free to do so, and we will convey those written questions to our panelists. So without further ado, I would like to start by introducing to you Virginia Petrova. Virginia holds a master's degree in international economic law from the Sorbonne Law School in Paris and a PhD in international law from the National Autonomous University of Mexico. She is professor of international law at the Iberoamericana University at Mexico City, and she belongs to the Mexican National System of Research. Her central research interests include dispute resolution in public and private international law, international investment law and arbitration, and international security studies. Virginia will speak to us about the role of the International Court of Justice in the resolution of interstate armed conflicts. Virginia, welcome, and you have the floor.
Thank you so much, Mariana. I'm very pleased and honored to participate in this webinar, and special greetings to our colleagues and our audience in China. We know it is very late, but thank you for the effort and thank you for joining us. As you were saying, I will present some reflections on the role of the International Court of Justice in the settlement of interstate armed conflicts. I will argue that the role of the court in the resolution of this type of conflicts has been very limited. However, its decisions in this field have strong symbolic and diplomatic implications that will also be discussed further. We must first bear in mind that, unfortunately, the scourge of war, in terms of the preamble of the UN Charter, is still one of the main threats to the international peace and security. In political terms, war is an act of violence that seeks to force an opponent to comply with one's will. In legal terms, according to the Geneva Conventions on International Humanitarian Law, war exists when armed force is used between at least two states. In this case, we are speaking of international and interstate armed conflicts, and I will only focus on this type of conflicts. We also must remember that recourse to the ICJ is one of the main means for the peaceful settlement of international disputes, according to Article 33 of the UN Charter. Pursuant to Article 94 of the Charter and the general principle of res judicata, the decisions of the court are binding to the parties, for the parties to the disputes. Thus, the court, as the main judicial organ of the UN, can actually issue binding judicial decisions on the resolution of interstate armed conflicts. The court had the opportunity to discuss the legal avenues for the resolution of this type of conflicts in the following cases: legality of the use of force, construction of a wall in the Palestinian occupied territory, declaration of the independence of Kosovo, armed activities on the territory of the Congo, legality of the use of nuclear weapons, East Timor, Ukraine versus Russia, application of the Genocide Convention is the latest case where an interstate armed conflict is involved. Some of these cases are actually advisory opinions of the court on some aspects of international armed conflicts. The resolution of each one of the contentious cases and the findings of the court in the advisory opinions show the limited impact of the court decision on the settlement of interstate armed conflicts. And I think that this limited impact is due to two main reasons. One is a political one, and the other one is a jurisdictional one. I will start with the jurisdictional limitation on the role of the ICJ regarding interstate armed conflicts. And in fact, the UN Charter itself and other international treaties do not include what we call a compromissory clause. That is a clause that enables the court to settle a dispute related to the violation of the UN Charter itself or the violation of other jus ad bellum rules. And we know that the jus ad bellum rules are the rules that govern the use of armed force in international relations. In the legality of the use of force case, for example, the ex-Yugoslavia demanded 13 NATO member states for the organization's military campaign in its territory since 1997. The jurisdictional basis of the claim was Article 9 of the Genocide Convention, which is not a treaty related to the violation of the rules that govern interstate armed conflicts. But the ex-Yugoslavia had actually no other choice than invoking a treaty on genocide for fundamenting the jurisdiction of the court regarding violations of the jus ad bellum rules. Exactly the same happened with the latest case of the court, Ukraine versus Russia, regarding the war in Ukraine. Ukraine once again based its demand on Article 9 of the Genocide Convention as compromissory clause, but it tried to seek from the court a determination about the legality of the Russian military intervention on its territory. In its order for preliminary measures, the court admitted that argument and considered itself prima facie competent to examine the war in Ukraine on the basis of the Genocide Convention, but in its ruling on the preliminary objections of the 2nd of February 2024, the court considered that the Ukrainian claims on the legality of the Russian war in Ukraine on the basis of Article 9 of the Genocide Convention were inadmissible. In two other cases that were not related to international armed conflicts, armed activities on the territory of Nicaragua and oil platforms, the court was more open to admit cases related to the legality of armed conflicts on the basis of the jus ad bellum rules. It considered in the first case in Nicaragua that these rules are part of customary international law, and in the second case, oil platforms, the court tried to use the methods of interpretation of treaties of the Vienna Convention of the Law of Treaties to include jus ad bellum rules, even if there is no jurisdictional clause in more treaties about these rules. But these arguments have never been applied regarding international armed conflicts. So the first reason of the limited impact of the court's decision regarding the settlement of interstate disputes are these jurisdictional barriers to the access to the court's judicial forum. The second reason for the limited role of the court in the settlement of interstate armed conflict, I think, is a political one, and it is related to the lack of coercive powers of the court, and especially the lack of political will of powerful state parties to the conflicts to comply with the court's decisions. As I mentioned above, according to Article 94 of the UN Charter, the decisions of the court are binding on the parties. However, even if they are legally binding, in practice, they have been ineffective. We can take the example of the interim measures pronounced by the court, in its case, Ukraine versus Russia. The court ordered interim measures aimed to stop state acts of violence during the war and to prevent the possible commission of genocide. However, to date, Russia and Ukraine have not complied with the order of ICJ, and it is because of Russia's veto power in the UN Security Council. This veto power implies that at present there are no judicial mechanisms that permit to the ICJ to stop an international armed conflict initiated by a permanent member of the Security Council. Interstate armed conflicts, when powerful states are involved, in fact, paralyze all the mechanisms of the UN, which can only act as a tiger without teeth, to use a famous expression of an ex-UN Secretary General. In addition to the dependence of the court on the political will of powerful states, there were also some very highly political arguments of the court in some of its advisory opinions on questions related to international armed conflicts. Illegality of the use of nuclear weapons and declarations of the independence of Kosovo, the court itself made some very controversial statements regarding the legality of nuclear weapons, which is one of the main causes of international armed conflicts, and regarding problems posed by secession as another cause of interstate conflicts at the international level. These are the two limitations I see, but even if there are some limitations on the role of the ICJ, I think that we should not underestimate the symbolic and diplomatic force of the court's decision. Through its practice, the court develops international law in a sense that conditions, restricts, and limits in some way the external level. The court, as the main judicial organ of the UN, guarantees the supremacy of international law in the international arena. The court also promotes some fundamental axiological objectives of the international legal order and has been an actor involved in the humanization of international law. So even if it faces challenges in its ability to control the legality of acts of powerful states during armed conflicts, the court still has important opportunities to condemn the use of armed force in the international level, to vindicate its neutral position in terms of political power and its adherence to the deeply humanistic nature of its international judicial function. And yes, we, the people of the United Nations, can expect from the court to protect us from the always devastating effects of the scourge of war. That will be all for my part. Mariana,
Thank you, Virginia, for this very interesting analysis of the opportunities, sometimes missed opportunities of the court of pronouncing itself in jus ad bellum in interstate armed conflict situations, and also the jurisdictional limitations and other challenges of lack of implementation faced by the courts in the court's judgments in recent cases. So without further ado, I am now going to introduce our next panelist, who is Shuki. Shuki is an associate professor in the School of Law of Jinan University. He specializes in the public international law, the law of the sea, and he has published some papers in the Chinese Journal of International Law, Ocean Development and International Law, Marine Policy, and other international law journals. Shuki is going to speak to us about reflecting recent case law before the International Court of Justice, a third-party intervention perspective. Shuki, you have the floor. Welcome.
Okay, yes. Good afternoon, Mariana, and good morning, Joe and Petrova, and also my Chinese fellows, good evening. And thanks everyone for joining this very exciting seminar. And actually today I would like to talk about my consistent research topic. So Mariana, can you see my PPT? It's okay? So everything is okay? Okay, all right, good. So today I would like to talk about the third-party intervention procedure before the International Court of Justice. Basically, I have three parts to discuss. The first is a basic introduction on this, what is the third-party intervention is before the ICJ, and the second I will introduce the past and ongoing cases with regard to the third-party intervention, and also reflecting some jurisprudence. And finally, I will give some concluding remarks. However, because my time is so limited, so I do not explain more details on the cases, but just analyze the cases based on the judgment and give some concluding thoughts on this. Okay, so actually, the third-party intervention is an incidental procedure or the proceeding before the court, which means that it's not the main part of the proceeding, but is incidental to the main litigation of the court. And it is stipulated under Articles 62, 63 of the statute. So actually, there are two kinds of intervention for the third state to intervene in the court. The first one is the Article 62, concerning that the legal interests of the third parties will be affected, possibly affected by the judgment of the parties. And the second is Article 63 of the statute, which means that as a third party to an international treaty, it has a right to intervene because of the interpretation of the certain provisions within the international treaty. So it also means the statutory intervention. However, from the international case law concerning the third-party intervention, actually the International Court of Justice has the jurisdiction over the intervention, and so it is not a problem to discuss whether it has jurisdiction or not over the intervention from third party, but the main issue here is about the admissibility of the intervention from third parties. So you can see the requirements from Article 62, 63, and also—
I'm very sorry to interrupt you. Should keep it. Your slides are not switching.
Oh.
Are you switching slides?
Let me try. Can you see it? I'm not sure, but maybe, sorry. Let me try again. Can you see it?
It's loading. Mariana? Yes,
can
now, yes. Now we can, yeah. Oh,
okay. There's always some problems. Yeah, it's okay. Now it's my slides now. So the issue of the intervention from 62 or 63 of the statute, but also Articles 81 and 82 of the rule of the court contain some conditions to decide whether the application for intervention in the proceedings can be accepted. And also Articles 83 to 86 are specific procedures for a third party to intervene in the proceeding. Okay. So next part is about the past and ongoing cases with regard to third-party intervention. So before the Russia-Ukraine genocide case, so before that case, we see recently the court decided on the jurisdiction of this case, and also it allowed the 33 countries to intervene in that case. Before that case, I would call the past cases before the genocide, the Russia-Ukraine genocide case. I have actually concluded several features from the past cases concerning the third party intervention. The first one is that in the past cases, the third party intervention often occur in the merits phase of the litigation, not much often, actually very, very few in the jurisdictional phase. This is the first one. The second is that the overall number of the cases compared with other cases is very, very small. And also the number of the cases, a number of the third party intervening in Article 62 is a little higher than the intervention and Article 63. But for most of the cases, they are concerned in the land and maritime boundary delimitations. And the success rate of the intervention is actually quite low. The third one is that in the intervening cases under Article 62, the ICJ has a very larger discretion in determining the legal interests of the third parties being affected. And also there's something actually quite vigorous and also unclear and also inconsistent practice, judicial practice concerning the determination of whether a third party is sufficient or not to be allowed to intervene under Article 62. However, because the time is limited, so I cannot analyze the case by case to tell you why it is insufficient. So, and also the first point is that under Article 59 of the ICJ statute, it states that the judgment is only binding upon the two parties to the dispute. However, if you look at the international maritime delimitation cases, the International Court of Justice in some cases have actually delimited the maritime boundary, which has affected the third party interest in the final judgment. The very salient example is the Nicaragua-Colombia case in 2012. Actually, I also published a paper in the Chinese Journal of International Law, which specifically discussed this case. Yes. And the final point is that since 2014, before the Ukrainian-Russian genocide case, there has been no mass or the large-scale third-party applications to intervene in the state proceedings before the International Court of Justice and Article 62 or 63. That means that most of countries actually in the past are quite cautious on this incidental proceeding, incidental procedure. And I think the things have changed since the 2004 in the case between the Ukraine and Russia genocide case. So we can see, so mass intervention from 34 states in the Ukrainian-Russia genocide case, and 33 states, except the United States, have been allowed to intervene in the case. And from the order of the International Court of Justice last year, and it allowed the 33 states to join in the proceeding. And from the order, we can see several interesting things. For example, the first one is that in the court has clearly said in the jurisdiction and admissibility stage, the third parties actually can be allowed to intervene under Article 63. And it overturning their decision to reject El Salvador's intervention in the jurisdictional stage in the Nicaragua case in 1984. The second one is that the number of the intervening states is not a problem at all. And also the intervention of multiple third countries does not violate the provisions of Article 63. Next. The intervention under Article 63 only concerns the interpretation of the specific provisions of the Genocide Convention, and has nothing to do with whether the dispute exists or the facts of this case. And in the jurisdictional judgment in February, which means last month, the ICJ actually rejected the Russia's preliminary objections based on the abuse of the process by Ukrainian and also by the intervening states. However, if you look at the jurisdictional judgment of the February, a very, very crucial point in that case is that whether Russia's actions fall within the jurisdiction clause of the Article 9 of the Genocide Convention, the ICJ did not accept the position of the Ukraine and also the intervening states. This is a very salient point of that decision. So I will go to my final part. I will give some general conclusions on the past and also ongoing cases relating to the third-party intervention. The first one is that after the mass interventions in the Ukrainian-Russian genocide case, 28th of February 2024, this year, the ICJ has amended the certain provisions of its rules relating to the intervention. The very, very apparent aspect of this amendment, you can see from the red line. So before this amendment, the ICJ allowed the intervention to be to apply no later than the oral statement date. That means even 1 day before the oral statement, you still can allow to apply to intervene. However, after the amendment, the court has changed the deadline for the submission of the application to intervene. And it means any state which wants to intervene in the case has to submit their application not later than the date fixed of the counter memorial. So that means it actually advances the deadline for any country as any third state to intervene in the case. I think is it because of the mass interventions of the genocide case. So the court is faced with a lot of work. So does that mean the court has a cautious attitude? I think it still can have to be seen. The second, the ICJ has recognized that the United States has presumed the legal interest in the interpretation of the Genocide Convention, and it can intervene, but it cannot do so because of reservations to the Genocide Convention, Article 9. This means that the presumption of the legal interest is the subject matter of the dispute by reason of being bound by the treaty, and the establishment by third parties of the right of intervention under 63 is a new condition under 63 because we always mention that the legal interest being affected by the subject matter of the case fall within the Article 62, but now the court actually used the legal interest affected standard in the Article 63. So this is kind of change. Second, the third, from the jurisdictional judgment, we can see, although 33 states actually submitted the oral statements of intervention within 1 day, the final judgment actually only examines the opinions of the intervening parties in 3 aspects, which actually are quite a few. So does this mean that the future large-scale intervention applications will also be very large, but finally the result is quite small? Fourth, against the backdrop of the increasing international public interest litigation, is there a prospect of a reviving Articles 63, 62, and 63? So we have there are 2 pending cases before the Court of Justice. The first one is the Gambia versus Myanmar, and there are joint declaration of intervention. And also in the South Africa versus Israel, there also the Nicaragua also applied to intervene. So we can see that in the actually increasing background of the international public litigation, I think the Articles 62 and 63 still have a role to play in the future litigation. So that's my presentation. I hope it is not very long. Thank you, Mariana. Yes.
Thank you very much for this very interesting analysis, Shuki, on an up-and-coming topic in the International Court of Justice, which is third-party interventions. As you mentioned, we've seen this recently in the Russia-Ukraine case, but we've also seen it in not only contentious cases, we've also seen third-party interventions very prominently in the advisory proceedings on the consequences of the occupation in the occupied Palestinian territories, which is ongoing. So I think it's a very interesting analysis that you make, and I think that it reflects the tendencies of the international community of more cooperation in the prosecution of international investigations. So I'm looking forward to the discussion. Thank you. I now will introduce to you José Joel Peña Llanes, our next panelist. José Joel Peña Llanes holds a PhD degree in law at the Institute of Legal Research of the National Autonomous University of Mexico, and he holds a PhD in public administration at the National Institute of Public Administration. He also holds a master's degree in international relations studies and a bachelor's degree in international relations from UNAM's Faculty of Political and Social Sciences, where he is an assistant professor. He is a candidate for the Mexican National System of Research and a member of the Mexican Council on Foreign Relations, the Mexican International Studies Association, the International Studies Association, and the International Law Association, Chapter Mexico. So José Joel Peña Llanes will present a case concerning jurisdictional immunities of states, specifically between Germany and Italy. So Joel, you have the floor. Thank you and welcome.
Thank you very much, Mariana. Can you hear me well? Yes, and can you see the slides? Great. Good morning, everyone. Good evening, and thank you for joining us. It is a great pleasure to participate in this webinar with Professors Virginia Petrova, Xiao Lulei, Chishu, Alexander Pereira, and also our great moderator, Mariana Salazar. Also, I would like to thank all the people who are connected to Zoom, especially those from China, because it's very late over there. So thank you very much. And obviously to all the people here in Mexico and in other parts of the world. And also I would like to thank the convening institutions for their support in organizing this webinar. Well, on this occasion, I would like to present a case concerning jurisdictional immunities of states, namely a case that arose between Germany and Italy, which was brought before the International Court of Justice. Under public international law, state immunity is a principle derived from the principle of sovereignty, independence, and equality of states, which prevents a state, its organ of government, or its property from being subject to the jurisdiction of another state. It implies the incompetence of domestic courts to hear claims against a foreign state and the impossibility of coercive enforcement against the assets of that states found in the territory of the foreign state. Dr. Virginia Petrova, in her book, Mexican Courts and International Courts, Complementarity or Competence, points out that there is a debate on the scope of such immunity, especially when acts are committed that constitute violations of jus cogens norms. In general terms, international courts have refused to admit the existence of exceptions to such immunity, but there are cases in which domestic courts have decided to interpret and apply international law to resolve disputes brought by one state against another, even in breach of judgments of the International Court of Justice. In 2008, Germany filed an application instituting proceedings against Italy before the International Court of Justice, arguing that Italy did not respect immunity from jurisdiction enjoyed by any state, in this case Germany, under customary international law. Germany requested the International Court of Justice to consider that Italy did not respect its immunity from jurisdiction by allowing civil claims to be brought against it before Italian courts, alleging reparation for damages caused by violations of international humanitarian law committed by the German right during the Second World War. In addition, Germany argued a violation of the above immunity by authorizing coercive measures against German state property located on Italy territory. An additional infringement was also argued since Italy declared enforceable the decisions of Greek civil courts rendered against Germany in similar cases arising from claims brought before the Italian courts. Finally, it was requested that Italy be declared internationally responsible. In this regard, Italy asked the International Court of Justice to dismiss Germany's request because they are unfounded. In fact, the Italian Supreme Court of Cassation ruled that state immunity does not apply in relation to international crimes. It is worth explaining that Germany brought the dispute under 1957 European Convention for the Pacific Settlement of Disputes, to which both states are parties, and which provides for the possibility for the contracting parties to submit to the International Court of Justice all international legal disputes that may arise between them. The International Court of Justice analyzed whether the Italian courts acted in breach of Italy's obligations to grant Germany immunity from jurisdiction by accepting the claims brought before them by Italian plaintiffs. In February 2012, the court ruled in favor of Germany by expressing that Italy breached its obligation to respect Germany's immunity under international law because it allowed that civil claims be brought against Germany in the Italian courts based on violations of international humanitarian law committed by German Reich between 1943 and 1945. Italy also allowed measures to be taken against German properties located on Italy territory. And finally, Italy allowed that decision of Greek courts based on violations of international humanitarian law committed in Greece by the German right be declared enforceable in Italy. The International Court of Justice considered it necessary for Italy to enact an appropriate legislation under or other methods to ensure that decision of its courts and those of other judicial authorities which violate the immunity enjoyed by Germany under international law cease to have effects. This means, in other words, that the Italian state was obliged to invalidate the judgments of its own courts. The International Court of Justice recognized that the United Nations International Law Commission concluded in 1980 that the principle of state immunity constitutes a general rule of customary international law. But what is the significance of this judgment of the International Court of Justice? First, it was the first case brought before the International Court of Justice that resulted in a pronouncement of state immunity. Secondly, it reaffirmed that the principle of state immunity is essential to guarantee the sovereign equality of states and stability in international relations. Thirdly, it confirmed the importance of respecting human rights so that a state cannot use its sovereign immunity to avoid accountability in cases of serious violations of such rights. However, in April 2022, Germany institutes proceeding against Italy for allegedly failing to respect its jurisdictional immunity as a sovereign state, arguing that Italy has not complied with the 2012 judgments, which has caused more lawsuits to be filed before Italian courts to obtain compensations for acts committed during the Second World War. It is important to note that in 2013, Italy, in order to fully comply with the judgment of the International Court of Justice, issued a domestic law to accede to the United Nations Convention on Jurisdictional Immunity of States and Their Property, including an article stating that the International Court of Justice had excluded the possibility of acts of foreign states being subject to the jurisdiction of the Italian courts in civil matters. However, in 2014, the Italian Constitutional Court declared that the International Court of Justice judgment could not produce any binding legal effects in the Italian systems, which is why it chose to declare the domestic legislation incorporating the International Court of Justice judgment into Italian law null and void. The court said that such legislation obstructed the right of access to justice for victims of serious violations of international law and thus contravened constitutional guarantees. Following the judgment of the International Court, Germany argued that, contrary to the judgment of this International Court, Italy will not dismiss the claims against it to obtain reparations for the acts committed by the Third Reich, and that the door will open to new claims. Furthermore, the violation of state immunity is reiterated because Italy is attempting to seize 4 German properties located in Rome to ensure compliance with the resolutions issued in favor of the victims. In April 2022, Decree Law number 36, entitled Additional Urgent Measures for the Implementation of the National Recovery and Resilience Plan, was introduced in Italy. Based on this decree, Germany inferred the termination of enforcement measures taken in relation to proceedings concerning compensation for damages suffered by Italian nationals as victims of war crimes and crimes against humanity committed during the Second World War. That is why, in May of the same year, Germany requested the International Court of Justice to suspend the ongoing enforcement proceedings against Italy, which was the main object of the request for provisional measures. Subsequently, in July 2023, just last year, the Italian Constitutional Court had upheld the constitutionality of a law creating an internal Italian compensation fund to satisfy claims by Italian individuals against Germany relating to the violations I explained above. This fact justified Germany's request after consultation with Italy for an extension of time for the submission of its writ that was accepted by the International Court of Justice. Beyond the accession to the United Nations Convention on Jurisdictional Immunity of States and their property, it should be recalled that all states must recognize the sovereign immunity of states in most cases, with some but very limited exceptions. This means that Italy, like any other state, is bound to respect the jurisdictional immunity of other states unless an exception recognized by customary international law or by a specific treaty applicable to the parties involved applies. In this regard, the new dispute submitted to the jurisdiction of the International Court of Justice by Germany will make it possible to review once again the arguments underlying the principle of jurisdictional immunity of states and their property, as well as to corroborate the repeated practices of states in this area. In this way, a further contribution will be made to the development of public international law. On this point, the one related to the exceptions to the principle of states of immunity, I agree with Anabela Sandri Fuentes when she states in an article recently published in the Mexican Yearbook of International Law that state immunity is not absolute and may be subject to certain exceptions, such as in cases of serious violations of human rights or international humanitarian law. In this context, the importance of balancing the state's immunity with the protection of individual rights and the need to ensure access to justice and reparation for victims of serious human rights violation is emphasized. As can be seen, this case is very interesting, especially because it is based on customary public international law and revives the issue of conflicts resolution between domestic courts and international tribunals. Furthermore, the discussion on the compatibility of this customary role with the judicial protection of the fundamental rights of individuals is crucial in the search of a legal system that guarantees justice and redress in cases of serious violations. Thank you very, very much for your attention.
Thank you very much, Joel, for this very interesting presentation and analysis on this case on jurisdictional immunities of states between Germany and Italy, and on the possibilities of identifying, I think my camera is frozen, I'm sorry. Can you hear me? Yes? Okay, on the possibilities of identifying also some exceptions to this very important principle. I now give the floor to our next panelist, Lei Xiaolu. Lei Xiaolu is currently a professor of international law in the China Institute of Boundary and Ocean Studies in Wuhan University. She obtained her LLM degree in 2009 and her PhD degree in 2012 from Wuhan University, specialized in international law. In 2017, she was a visiting scholar at S. Ratnam School of International Studies, Nanyang Technology University of Singapore. Her research interest covers the area of Pacific dispute settlement mechanisms, especially the peaceful settlement of the South China Sea disputes, China's maritime law and policy, and the legal issues in the law of the sea and the general international law. So Lei will speak about us on small island states, and I here give you the floor to speak about the role of climate advisory opinion before the International Tribunal of Law of the Sea. You have the floor, Deschelle.
Okay, thank you. But my topic today will be about the ongoing advisory opinion proceeding before the ITLOS. I think about this topic, there are 3 ongoing advisory opinions, right? One is before the ITLOS, the other is before the Inter-American Court of Human Rights, and the other is before the ICJ from the broader perspective of this issue. But according to the request raised, the causes, the time of the initiating of those advisory opinions, I think the ITLOS may be the first to speak about this issue. So I choose the first advisory opinion, maybe the possible first advisory opinion on this issue to discuss about. So today I will focus on 3 issues today. First of all, I'd like to identify the main legal issues in this case. And secondly, I'd like to discuss some of the dilemmas of the key issues. And thirdly, I will discuss the possible contribution of the UNCLOS, the advisory opinion, to address climate change impacts. And first of all, we can see that in 2022, the causes has requested advisory opinion from ITLOS on 2 questions. To me, the first is about the application and interpretation of Article 1 and 4 of the Convention. And the second is about more broader obligation of preserve and protect of the marine environment under the Article 192 of the Convention. So I think this most important 2 issues on in this case. And I think there are 3 dilemmas I think I can address here. I think the first is the inclusive nature of the Part 12 of the Convention and the global nature of the marine environment degradation caused by climate change. What I mean by this, if we read the Part 12 of the Convention, we'll see that the intention of the drafters is to include all kinds of pollution or the deleterious effect to the marine environment into this part to be regulated. We can find this intention in the context and in the draft history and preparatory work of this of the UNCLOS. For example, the definition of the pollution of marine environment in Article 1 is a very inclusive definition of the marine pollution. And in Article 194, it emphasizes the states will take all measures necessary. So it will include lots of measures and an inclusive list of measures. And in 1 and 2, it indicates they have obligation to protect and preserve marine environment in a so general and a generic words. So we'll see the intention of the drafters or the parties is to include all kinds of deleterious effects they foreseen and unforeseen in that time. However, when the drafters make those provisions, they are willing to get all things together. But at that time, they do not realize that the climate change may be other deleterious effects which have the global nature. It's very different from the traditional transboundary harm they already get to know at that time. I think there are at least 3 characteristics of the global nature of the marine environment degradation caused by climate change. First, it's not caused by individual states, but from the international community. Every state emit the GHG gases, right? Not just one or two the states. Secondly, the deleterious effect is caused by excessive emission accumulated in a very, very, very long time since the in this industrial revolution. And thirdly, the deleterious effect will be always lagging off. It will happen very long time after the conduct happened. So it's very different from the traditional transboundary harm, when especially reflected in the paragraph 2 of 194 of the convention. It says that there might be some marine pollution under the control of one state will release to the other state and to the high sea and the area. So it's very different from that kind of part. And if we look into other parts of environmental law, for example, the atmospheric pollution, the RLC work of the draft guidelines also indicates the two kinds of deleterious effect brought to the atmospheric problems. It says that even in this guideline, they say the appropriate measures to prevent, reduce, or control apply to both kind of deleterious effect, but the measures may be very different. And they also noted that the existence of this obligation in customary international law is still somewhat unsettled for the global atmospheric degradation. So it also indicates that the international law applied might be different from the two kinds of deleterious effect. So, and I think this is the first problem the ITLOS may be faced. You should consider the difference between the marine environment, the degradation caused by climate change, and traditional marine pollution. And secondly is about a due diligence obligation. As we all know that the almost all the obligations under the Article 192 and 194 are due diligence obligation, which means that it's an obligation of conduct, not an obligation of result. And many of the jurisprudence before the ITLOS has proved that, has confirmed that due diligence is an obligation to deploy adequate means. It's not to, it asks you to try to do the utmost, but not to require you to achieve some of the certain results. So the due diligence obligation usually do not have a fixed content. It will depend on the case-by-case analysis. And it also have some discretion of the state to decide according to its capacity, according to the foreseeability of the harm, to choose some of specific measures in exercise of the due diligence. So I think it's very difficult for the tribunal in advisory opinion to settle international standard or regional standard for the due diligence obligation to address the climate change impact of the marine environment. Usually only in the contentious case, the court or the tribunal will evaluate whether the due diligence obligations are fulfilled on a case-by-case basis, right? But ITLOS may indicate the factors that could be taken into account, or the parameters of the due diligence in this advisory proceedings. For example, the best available science, the capacity of states, and sustainable development, especially the interpretation of all those articles in combination of 1 and 3, which means that sustainable development is also very important when we consider marine environment protection. And I think that third problem will be the relationship between the UNCLOS and the legal regime of the climate change. And there is many discussion on which one is a self-contained regime or a special regime in the written statement and the oral proceedings of all those states. Some states believe that the legal regime of climate change is a special regime that will be applied as specially before the UNCLOS. But most of the states believe that through the article VCLT Article 31(3)(c) will take all this kind of international law that could apply together to interpret the Part 12 of the convention. And also the convention also contains some reference clause. For example, the Article 237 and some of the garis in Section 5 and Section 6 to incorporate with the legal regime of the climate change together to identify the due diligence obligations. And contribution of the UNCLOS could make. I think we'll start with the question of impact of the advisory opinion. First of all, we all know that advisory opinions usually have no legally binding, but we can find that in the Maldives and Mauritius case, we see the significant profound impact of the advisory opinion because of its authoritative and prominent nature of that. Have some legal consequence of the advisory opinions. So at least we think that I think that the climate advisory opinions will at least clarify some obligations under the UNCLOS to address the climate change impact. But we will have why we have this kind of climate advisory opinion, we'll get a solution from that, or we'll have a standard for allocating the shared responsibility to every country by this kind of advisory opinion, or someone wish to get a legal basis for the future lawsuit of the responsibility of states. I don't know, but but maybe this is the motivation behind those advisory opinions. But I'd like to invite everyone to think about a question at this time, at this stage of issue. Is it important to encourage the state to commit more, to do more, to make more effective NDCs or something? Or it's the time to clarify the obligations and prepared and get ready to get the responsibility of each state. And I think it's far from the maybe from the personal point of view, encourage states to might more important than the other one in the current stage. So if we look into the obligations under the Article 192, we find a way out, or we find the way that UNCLOS really can contribute to address the climate change impact. Generally speaking, Article 192 will have broader scope of 194. It also contains an obligation of to take adaptation and resilience strengthen measures against harmful consequence. And this will reflected by other frameworks or legal frameworks such as CBD, BBNJ, and it can reconcile with the legal obligations under the climate change legal regime. because the adaptation and increasing resilience to climate change are also core to the global climate change regime under the UNFCCC. So if you consider this, I think we'll get a brighter future. We shed the so by doing this, I think the advisory opinion proceeding maybe shed a light on the cooperation or the future work of the climate change impact. That's my topic today. Thank you.
Thank you very much for this excellent presentation, Lei Xiaolu, on a very important topic. I think it's going to be very interesting to see the effect of this advisory opinion, precisely as you mentioned, upon possible further litigations by countries, but also the effect upon the other advisory opinions that will be rendered in the other courts. So I think this is a very interesting analysis. Thank you very much for this. And last but not least, I want to introduce our last panelist, Alexandre Pereira da Silva. Alexandre is an associate professor at the China Institute of Boundary and Ocean Studies, also at Wuhan University, focusing on Latin American state practices. He was a visiting postdoctoral scholar at the Marine and Environmental Law Institute in Dalhousie University and associate professor at the Federal, and he has published several articles, including in reference journals as Ocean Yearbook, Marine Policy. I will speak about the lack of contribution of the International Court of Justice and the United Nations and the International Tribunal of the Law of the Sea concerning the regime of islands under Article 121 of UNCLOS. So the floor is yours, Alexander.
Thank you, Mariana. Can you all see my PPT? Great. Firstly, let me express my joy and my pleasure to be part of this event. It's great to share this webinar with my dear colleagues from China and as well from Mexico. So I'd like to also to congratulate all the previous speakers for their presentation. They're quite interesting, as our moderator highlighted. So without further ado, I'd like to start my presentation, which is like a different approach from the previous one, because it's something about the lack of contribution of the permanent tribunals to deal with this very interesting and topic in international law of the sea, which is the regime of islands, and in Article 121. So this is the outline of my presentation. So briefly, I'll introduce the Article 121 and then see the opportunities that the ICJ had to discuss this regime of island, and then the ICLUS, and then very summarize some aspects of the South China Sea Arbitration Award, and then ending with some concluding remarks. So the regime of islands in UNCLOS, the United Nations Convention on the Law of the Sea, is just one article among the 320, and it splits in just 3 paragraphs. So the first one is just the definition of an island, so which is not to reform land area surrounded by water above water at high tide, and the paragraph 2 just gives to island or full entitled island the same maritime entitlements that any land area, which means except as provided in the UNCLOS. An island has a continental shelf, a territorial sea, contiguous zone, EEZ, and continental shelf. While if this insular feature is just a rock, then is only entitled to a territorial sea, and eventually also to a contiguous zone. So the difficulties of this article is not on the paragraphs 1 and 2. So paragraph 1 is like kind of verbatim reproduction from the previous convention in 1958. While the paragraph 2 also is not controversial. So the real discussion, the regime of island lies on the paragraph 3, because rocks which cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or continental shelf. Though there's no guidance in the UNCLOS as how the expressions human habitation and economic life should be interpreted. So there is a lot of discussion among international scholars about these two expressions. So the regime of island can be identified in two main aspects. So one is the maritime area generated by then in terms of fully entitled islands and rocks, and the other is the impact for the limitation of maritime areas between states in terms of opposite or adjacent coasts. What I just want to highlight, just to conclude this first part, is the big difference, the substantial difference between one thing and another. So which means if it's an island, it's entitled to more than 400,000 square kilometers. Though if it's just a rock, then it's entitled to only a bit more than 1,000 square kilometers in terms of territorial sea. So we are talking about a huge difference between one thing is a rock, one other thing is an island, though they are above water at high tide at any insular feature. So let's see if the ICJ, the International Court of Justice, had the opportunity to discuss these aspects on the regime of island. And indeed, the ICJ had more than one opportunity to make some contributions for the Enlightenment in terms of application and interpretation of this Article 121. On the 1951, the fisheries case in the UK versus Norway, and the 1953 in the case of France versus UK, and 1993 on the Greenland and Yemen case. So, but none of those cases, the ICJ had discussed or make any like substantial or even like very little contribution for the interpretation of the Article 121. I just want to highlight just two cases from the ICJ, which are more recent. So one is the Qatar versus Bahrain case. So then the court in that case said the Article 121 is part of customary international law. Okay, so that's one contribution. And the court assessed it, the condition of one's insular feature was to assess if it was an island or low tide elevation. And the court, considering the Qatar versus Bahrain case, that particular insular feature, it was an island, though did not elaborate on the reasons, and it's not a clear contribution was made by the ICJ in that case. Maybe surprisingly, in the case of Nicaragua versus Colombia case, which is there's so many insular features in the case, near the Caribbean Sea, sorry. So it was like a good opportunity for the ICJ to make a real contribution for this subject. Though again, so the ICJ reaffirmed the customary international law status of the Article 121, but no particular guidance was provided by the ICJ on the island rock distinction and interpretation of the Article 121, paragraph 3. So again, so the ICJ lose a very good opportunity to make a substantial contribution for the interpretation and application of these provision. So let's see the ITLUS. So maybe ironically, but the ITLUS has no really possibility or chance to discuss Article 121. Although there are two cases that I want to briefly mention. So the first one is like the Montconfurco case between Seychelles versus France, and the ITLUS consider Kerguelen, which is near the Antarctica, as entitled to an EEZ. Although the living conditions there, if there is any living condition, there is a very, very difficulty. Though I just in the decision there is no mention to the distinction between rocks and islands. So just consider that Kerguelen as an insular feature has or is entitled to an EEZ and continental shelf. Though I just want to highlight the declaration of Judge Vukas, so that he said it is highly questionable whether the establishment of an EEZ of the shores of these uninhabitable and uninhabited islands in accordance with the reason of the motivation of the UNCLOS. But he did not really elaborated the distinction between rocks and islands. Again, in the Volga case, Russian Federation versus Australia, so not very far from the Kerguelen, there was again the discussion if Heard Island and Macedonia were entitled to an EEZ and continental shelf. And again, so the ITLU as the ICJ declined to make an assessment or to make a contribution for the interpretation of the Article 121. Though again, Judge Vukas made a declaration and briefly stated some of his approach, and he said that I dissociate myself from the statements of conclusions of the judgment on the EEZ of Heard Islands and Macedonia Islands. All these economic interests or concerns do not exist of the inhabited islands such as Heard and Macedonia. Okay, so what Judge Vukas says, okay, so Heard and Macedonia Islands are not islands, so they are rocks. Though the decision, the dissenting opinion of Judge Anderson, just in a very brief footnote, he just says, so Heard Island is clearly an island and not a rock. So you can see easily there is an opposite and conflicting view of these two judge islets. Then you can see how difficult it is. So then again, then the arbitral tribunal, constituted under Annex 7 of the UNCLOS on the South China Sea, kind of became the leading decision on this subject. Why? Because it was like the first decision that had really faced the Article 121. And I would say that the result of the award is at least very, very controversial. And the contribution, it's like very weak. I mean, no real contribution in terms of the South China Sea regarding the interpretation of Article 121. Why? So basically, because like the conclusions of the South China Sea award regarding again the Article 121 are not based on state practice. So then the contributions or the approach of the decision do not reflect at all what states are really applying in terms of interpretation and application of these provisions. Though, very briefly, so the ICJ said that on paragraph 553 said there is no evidence for an agreement based on open state practice on the interpretation of Article 121, paragraph 3, which differs from the interpretation of the tribunal. So among the more than 1,000 paragraphs, just 2 are dedicated to state practice. They say, no, there is no agreement that our conclusions differ radically from what the states are applying in terms of state practice. And this is not correct. So as you can see, there's a lot of cases that completely contradicts the main conclusions or the main findings of the South China Sea Award. So just to ending my presentation. So firstly, so Article 121 has been subject to intense debate over the interpretation and application among legal scholars, and we are very far from any or for very few conclusions. Those the views are very different. So, and the lack of contribution of the ICJ in the ATLU has created this gap that was kind of fulfilled by the South China Sea Mercosur. However, the findings of the South China Sea Mercosur seem to complicate the issue even further, since they are not consistent with state preference. So the status of the South China Sea as a leading decision concerning the regime of violence should be challenged and be considered very carefully. So thank you all, and thank you, Mariana, for your time.
Thank you very much, Alexander, for this very interesting analysis of international jurisprudence on what is a rock and what is an island. And I think it's a very interesting and important debate. So we have 9 minutes, and I do want to hear all of you in general about the interrelation of all of these possible influences between one court and the other, between arbitral tribunals and between international tribunals. In general, for example, on third-party intervention, what prospect do you think this might have in the future, maybe in other courts? What relationship do these decisions that you all have mentioned have with other courts, such as other cases in the International Court of Justice, the International Criminal Court, and how, for example, the ICJ's judgment on jurisdictional immunity might affect issues of accountability for violations of international humanitarian law? These are very open, general questions, just to set the floor for last 2 minutes by each of you for comments. And so I will start in the inverse order that we spoke. So Alexandre, just 2 minutes of concluding remarks or anything you want to comment on the other presentations or on this general question.
Okay, thank you, Mariana, again. So it's I just want to be focused on this case to have 2 more minutes or less to continue the issue of the Article 121, the possible influence of the South China Sea over. So my question essentially is, so how can we consider? So it's some of the scholars are saying that so the South China Sea is a leading decision on this subject, and I really oppose to that particular view. I really don't see that, and I hope that the ICJ and the ICLUS consider this as a very influential in their eventual and future decision. I hope the ICJ in the following opportunity, when they get the opportunity to discuss the Article 121, really make a contribution. And I will hardly believe that the ICJ and the ICLUS can give a real weight for the South China Sea award. As I said, because I really don't think they made a real contribution for the debate. Thank you, Marianne, for your time. Thank you all.
Excellent. Thank you so much. Leisha Lu, 2 minutes concluding remarks.
Okay, thank you very much. And I think it's very difficult for the international tribunals or courts to have the balance between the 2 functions. One is to resolve the dispute, the other is to develop the international law. Sometimes it will be, if it cannot keep the balance between the 2, maybe the international law develop, but the dispute or the conflict remains unresolved. So it's very difficult job for the judges. So that's my comment on on this issue. Thank you very much. Thanks for your time.
Thank you. Very important comment. And Joel Peña, 2 minutes concluding remarks.
Thank you, Mariana.
Joel, sorry, Virginia. Joel.
You said Shuki. I heard. Sorry.
Joel Peña. Sorry.
Thank you very much. Well, in fact, I think that the International Court of Justice judgment, the one that I explained before, underscores the primacy of jurisdictional immunity for states, even in the fact of serious violations of international humanitarian law. The court emphasized that under customary international law at the time, a state accused of such violation does not lose its immunity. The distinction drawn by the court between the legality of actions and the question of immunity in civil proceedings is crucial. The judgment suggests that the rules of state immunity are confined to determining whether the courts of one state can exercise jurisdiction over another state without delving into the legality or illegality of the specific actions in questions. The court rejected the argument that a state's entitlement to immunity should be contingent upon the existence of effective alternative means of securing redress for victims. Instead, it emphasized that the focus of immunity rules is on the jurisdictional aspect, not the underlying conduct. In essence, the court's decision maintains a clear separation between the legal accountability for grave violation of international humanitarian law and the immunity granted to states in civil proceedings. This raises important questions about the broader implications for the balance between upholding accountability for historical injustices and respecting the sovereign immunity of states under international law. The ruling prompts discussions on potential reforms or development in customary international law that could better address these complex and sensitive issues, as I pointed out in the conclusion of my presentation. Thank you very much, Mariana.
Thank you, excellent, Joel. Shuki, concluding remarks.
Yeah, thank you, Mariana. I want to make 2 quick points, and the first one is actually, I think the International Court of Justice is restraining itself in the genocide case concerning third-party intervention, because it actually has made clear that the court cannot decide the act to prevent the commission of genocide. It only can deal with the act of violating the genocide convention. So I think the strategy of the Ukraine and the Ukraine-Russia genocide case is clear, and also, but if you compare it with the third-party intervention and the court jurisdiction judgment, I think the court is actually refining its procedures and its understanding of the third-party intervention from many countries. I don't think it's really send a very negative signal for many countries to participate in the litigation before the court. However, I think, especially according to the amendments of the rules for intervention in the rules of court on February, I think the court actually do not limit the countries to submit their application to intervene, but they just want to refine their procedures to make them not very much overloaded. So I think, especially now, once there are conflicts between states, there are still, the violations of human rights. I think that's very natural, and also it's common thing. So for the international human rights treaties, I think it really now from the Gambia versus Myanmar, if you look at the jurisdiction judgment and the erga omnes parties with respect to the international convention, actually has been encouraged by the court. So I think the prospect of the Article 62, 63, I think it is still continued from that. I think perhaps in the South Africa versus Israel, not only the Nicaragua, but also other countries will join in the future, I guess. But they just have to see what's the situation going on. Okay, thank you very much. Yeah.
Thank you so much, Shuki. And finally, Virginia.
Thank you, Mariana. Well, our webinar was about the role of international courts and tribunals in the resolution of interstate disputes, and we analyzed the role of the ICJ and the role of IDLOS and the role of arbitration. And I think that we can conclude that all courts and tribunals exercise a complementary judicial function. Regarding mass atrocities and war, which was my subject, I think that the role of the ICJ is complementary and very depending on the role of the ICC, on which you are also an expert. We have 2 pending cases. Shu analyzed the case Ukraine versus Russia. He also mentioned the case South Africa versus Israel. well, both cases are pending before the ICJ, but also before the ICC. The ICJ will have to determine the legal responsibility of states for the commission of genocide, and the ICC will have to prosecute individuals such as Putin and others who have been accused of the commission of war crimes and genocide. And there is a demand as well against Hamas. So courts are complementary, and rendering international justice, as Lei was saying, is a very difficult task before the courts, but they're doing their best. Thank you, Mariana.
Thank you, Virginia, and I fully agree. I think that we've touched many topics, but what we can see is that there is an active work functioning of international courts and arbitral courts as well, and that, as mentioned by Virginia, these all may integrate themselves. Long gone are the discussions on fragmentation. I think we can speak about an integration and a mutual influence, and let's hope that these different jurisdictions and different approaches to each tribunal and to each jurisdiction simply serve to further strengthen the applicability and enforceability of international law that we are so lacking nowadays in the international legal sphere. So thank you very much, everybody, for participating. I know it's very late at night for some of you in China, so thank you very much, and we hope to see you next time. Thank you also to the panelists for this great panel, and have a great rest of the day for those who are in Mexico.
Thank you.
Thank you so much.
Thank you.
Good night and
Thank
good
you
day.
very much.
Bye-bye. Thank you.